Hi, very good morning. This is a Delhi High Court judgment on arbitration. National Highways Authority of India versus Afghans Infrastructure Limited. Section 37. So, brief facts. NHA, that is National Highways Authority, invited bids for some work. Let us not get into the details of work. Some work, whatever it is. AAL, that is Afghan Infrastructure Limited, submitted its bid that was accepted. Agreement entered, terms and conditions contained in the general conditions of contract and the particular contract were entered. Project cost was 183 crores. So during the course of the construction, engineer of NHA, he was of the opinion that AAL was not entitled to Afghan infrastructure. Hereafter I will say AAL. NHA is National Highways Authority. So that engineer of NHA was of the opinion AAL was not entitled for payment to embankment work done below the original ground level. AAL disputed, and it also said we want to refer this matter to dispute review expert. So it wrote a letter in 2003. Unfortunately, at that time, DRE was not in existence. It came into existence only in 2004. AAL made its claim before the DRE in 2005. So DRE was constituted in 2004, but AAL made its claim before DRE in 2005. DRE passed an order. It allowed the claim of AAL. Then NHA invoked the arbitration clause. It filed its statement of claim before the tribunal. The tribunal, after hearing the matter, rejected the claim of NHA. It decided the matter in favor of AAL. Then NHA filed a Section 34 application challenging the award of the tribunal, arbitral tribunal. They raised three issues. One is AAL is only entitled to payment of embankment work done at original ground level, not the ground level. Then the second contention was any claim opposing the decision of the engineer should be filed within 14 days of such a decision of DRE. Claim was raised only after 2 years, that is 2003, but they made the claim in 2005. Hence, the claim is time barred. That is the second submission. Third is they wanted price escalation should not be awarded at any rate, at uniform rate. So that is another contention of NHA. A single judge heard the matter, Section 34 application. Then he passed an initial order. The date is important, that is why I am giving. Initial order is dated 24th August 2012. The judge rejected the challenge raised by NHA with regard to point A. That is, AAL is only entitled to payment of work above the ground level. Why he rejected was it was a concession made by a senior counsel based on some judgments. So the senior counsel before the tribunal said, no, this matter is covered against us. Hence, you please let it be decided against the NHA. That is what the senior counsel submitted. So based on the concession, the award was given. Second one was with regard to the delay in approaching DRE, the judge held that at the time when AAL expressed its intention to refer the matter to DRE, there was no DRE. It was not in existence in 2003. Hence, that objection was also rejected. There was no delay, according to the single judge. Then, in the initial order, the single judge issued a notice, limited notice to decide the issue of adoption of uniform price adjustment in price escalation clause. That is the only issue I will consider. Balance two issues I will not consider because one is concession given by senior counsel. Second, it said no, there is no delay because at that time there was no DRE. So he issued only notice with regard to price escalation clause. Then, after hearing the arguments, the judge rejected the appeal of the NHA in 2014, June 2014. Now, NHA filed a composite appeal against the initial order dated 24th August 2012 and the final order dated June 2014. So they said that initial order, uh, which allowed only price escalation clause only, I will consider. That order also they challenged. Then 2014 final order, which rejected even the price escalation claim. That also, that is against the price escalation clause. That also they challenged as a composite appeal. Now, AEL submitted this appeal itself is not maintainable. It's a composite appeal. It should not be allowed. The Delhi High Court relied on the judgment of a full bench of Delhi High Court, which held that an appeal under Section 37 can be filed against non-issuance of notice on particular issues while issuing notice on the remaining issues. There is no bar in filing two appeals in respect of a petition filed under Section 34 of the Act. A person aggrieved can file an appeal against an initial order rejecting one or more of its challenges to the award, as also against the final judgment passed in Section 34. Against the order refusing issuance of notice on particular issues, the aggrieved party has the right to file an appeal at either of the two stages. One at the time when the order refusing the issuance of notice has been passed, and the other at the time of passing of final judgment. That is, simply put, the full bench said against the refusal to issue the notice, the aggrieved party has got a right to file appeal. Either he can file immediately. Once they refuse, immediately he can file an appeal. Otherwise, also he can wait up to the final order. Then once the final order is passed, then also they can file a composite appeal. Based on that judgment, the High Court held the appeal is maintainable. So second is on the merits, the payment in respect of the work, the Delhi High Court refused to interfere with the order of the lower court, as it was based on a concession. Senior counsel has given a concession. Matter is over. Then where is the question of interfering in that order? Delhi High Court said, no, we will not interfere. Even if it is because they relied on some other judgment and said, we have a good case. He said, no, a concession has been given, then the matter is over. You cannot file an appeal. Then with regard to delay in approaching DRE, the High Court said, they have to approach the DRE within 14 days. They agreed. But AEL expressed its intention to approach the DRE in 2003. At that time, it was not there. The delay is because of the NHA alone. NHA constituted DRE only in 2004. Now you cannot come and say that no, you should have approached the DRE within 14 days from the rejection of the that is the engineer's decision. That you cannot say now. The court noted that the tribunal has given cogent reasons in arriving at that finding, and AEL could not be held liable for the delay. So NHA took its own sweet time in consulting the DRA. So the court rejected this submission also. Finally, with regard to price adjustment, the court said, no, till the penultimate bill, NHA has paid all the price adjustments as claimed by the party. Only in the final bill you withheld the amount. Since you have paid for all the bills, where is the question of saying, no, this price adjustment at uniform rate is not applicable? They said, no, there is no illegality in the award, and hence they rejected the entire appeal under Section 37. So, very interesting judgment. One or two points which you should notice against the issuance of notice, refusal to issue notice, you can file an appeal either at that time or at the time of challenging the final order. That is one point. Second is that 14 days limitation is there with regard to expert committee's decision. The engineer, whenever the engineer rejects, you have to file a application before the DRE within 14 days. These 2 points are very important because NHA is giving a lot of work. Thank you very much. Have a great and wonderful day.